I'd like to apologize. We thought we could eat that quickly, but apparently we could not in town. So on behalf of the commission, we apologize to the parties and to those in attendance. We will make sure that doesn't happen tomorrow. Judge Allred, you indicated you had some preliminary matter, something you wanted to bring up.
Yes. Please, the Chair of the Commission. In regard to the motion granting the dismissal of the counts 4 and 20, the Commission advised that they had granted and dismissed those counts. I would request that in regard to the other motion to dismiss, in regard to the John Clem allegations, the Commission reconsider that ruling because it was filed based on the exact same violation of Supreme Court Rule 4.170 subsection 4, under the same assertion that evidence also had been intentionally not turned over to me because of the 1-year time limit to bring these formal charges. And I ask this with all respect, that logically, if you dismiss one for that, how can you not dismiss the other for that same legal argument? So it's a purely legal argument, and I would ask you all to reconsider it.
Mr. Bando.
Mr. Kelly.
Mr. Kelly.
Your Honor, I'm not exactly sure what the rationale of the court was for dismissing 4 and 20, but at least our argument in response to 14 and 15 was the information that hadn't inadvertently hadn't been produced didn't provide any information as to the charge, the nature of the charge. All the information required in the Supreme Court rule was given to Judge Allred through the statements from the witnesses that formed the proof that we're going to provide, which is the statements from Kurt Stallard. He was aware of it. All it was just the official unemployment records indicating the amount and totals of the benefits received, which really aren't to the heart of the charge. The charge is that the allegation was that Judge Allred had requested the jailer not oppose the unemployment benefits for someone who was otherwise not entitled to them. All that information was provided. The rule was met, and we think the Commission was correct in its initial ruling denying his motion to dismiss those charges.
Judge Allred.
Just briefly in response to that, I know that you all probably haven't seen those 17 pages of documents yet, but one of the interesting things about those 17 pages of documents indicated that Mr. Clem had to actually appeal. He was denied his benefits the first time and actually had to appeal and have a hearing to get those benefits. That would have been an interesting thing for me to raise in my response if I'd been given the opportunity under 4.170 subsection 4 before I was charged under Supreme Court Rule 4.180. My position is that these Supreme Court rules are ironclad. They're rules there to provide me the opportunity to respond. And when I realized that documentation wasn't provided to me, it really didn't dawn on me until I realized that there was an order in place that said these matters had to be charged by February the 21st, 2011, it would be barred, time barred. And if you're going to Harlan, you're sending your investigator down to get documents from the jailer, particularly ones that have any documents really, with the rules written, but documents that you're going to use to charge me, at the very least, I should see them before I'm charged. At the very least, I should be given the written opportunity to provide evidence of my own. I mean, that's Supreme Court rule. That's not my rule. It's not my argument. I don't see any leeway there in regard to that, and particularly coupled with the obvious reason that it was not turned over to me was because if it had been turned over to me in mid-February, and I'm given the opportunity to respond to this, February 21st, 2011 was the drop-dead date to have these charges in there, and it's clear. This is not just a good faith, I messed up, I've got to put on the record. My position is this is clearly an intentional act because they're faced with the unwarranted choice of 1-year time bar for violation of Supreme Court Rule 4.170 subsection 4. You know, it's easier to I guess I assumed it was easier to wriggle out of a 4.170 subsection 4 violation than a time bar where an order was signed that had to be charged by the 21st. And my only point is that every time new evidence came up in this case, every time it came up, I was given an opportunity to respond to it. That's my Supreme Court rule, not a caveat of the prosecution or the committee. It's something the Supreme Court has required to be done. In this case, it was ignored. It was ignored in one that you dismissed, and thank God you saw that. It was clear. The other one is the exact same thing. 17 pages of documents that were used in the charge. What's so funny about it is the charging instrument, the charging document, specifically references material facts that were in those 17 pages and not in anything else that was given in regard to Kurt Stowers' testimony. And the standard is not, well, he had enough to file a response. That's not it. The standard is shall. And Black's Law Dictionary makes it very clear that shall means they shall do it. There's no option in it. And in this case, exactly what happened in this case, and it's not Mr. Mando's fault, and it's not Mr. Kelly's fault. They got into this after. They didn't even know about the violation until I brought it to their attention in a telephone conference or a conference of some kind. And my point is, that's what I'm here for. And, you know, the Supreme Court rule is what I have to follow. And the Supreme Court rule was established to give me that opportunity to respond to that evidence and use that evidence before I was publicly charged under Supreme Court Rule 4.180. There is no doubt that was a violation. My position is that that was done intentionally because of this looming drop-dead deadline of charging. But that's my position. Thank you.
Go ahead, Mr. Cole, briefly.
Judge, I was just going to say there was no intentional withholding of the information. The information is not relevant to the charge. We had no intention of even introducing this evidence because to us, the proof in this is through the statement, through the direct contact between Judge Allred and Mr. Stallard. We can agree that the evidence wouldn't be provided because we weren't going to use it anyways because we didn't find it relevant or material. The rule says the factual information that forms the basis of the charge is provided. That information was provided to Judge Allred. I think the rule's been satisfied.
Mr. Mando, as a matter of proof, so we can see where we're going, where is this going to be discussed? In other words, we need to resolve that issue, but if that's not what you're going to next, we can do it at a break.
No, I do not intend to cross-examine Judge Allred about that particular matter.
We will take a break before you do so we can revisit that.
Certainly, because I don't anticipate presenting any proof on that point, maybe even this afternoon.
Okay. All right. We will resolve that issue, Judge Allred, before they would ask you about those charges.
Thank you. I guess you want back on the stand now?
Yes, please, Your Honor. Thank you.
Judge, obviously you recall that you're under oath.
Yes, sir.
And to the extent, Mr. Chairman, too, to the extent we have to remind anybody it's hard for me to keep track, but the recusal in light of the break and lunch, I just want to make sure that the separation order is still in.
If there's anyone in here who could be a witness, they need to step out of the courtroom. I think everybody who's here I've seen all morning,
Okay.
so I don't
Thank you.
think
Thank you, Mr. Chairman.
Thank you.
Judge Allred, it's my understanding that on or about April 16th of 2008, that you filed a complaint with the Public Service Commission against Kentucky Utilities, alleging that they had unlawfully billed and collected from you for certain fuel adjustment charges for both you and some companies you have an ownership interest in. Is that correct?
Yes, over the course of years, yes. One of those companies would have been my old law office, Russell D. Allred, attorney at law, PSC. May I get up for just a second?
Certainly. Let me hand you what I marked as Exhibit 16.
Yes, sir.
Is that a copy of the complaint you filed with the Public Service Commission?
Yes, it is.
All right. And am I correct, Judge, that that was filed on April 16th of 2008, correct?
According to the stamp on it, says received April 16th, 2008, so I would assume that's correct.
Then it's my understanding, Judge, that at some point after the complaint was filed, sometime later in 2008, that you had a conversation with counsel for Kentucky Utilities about your complaint.
I guess. I'm trying to remember which conversation you're having. I think we actually had a couple of them.
Okay. Let me show you, because I think this will help
Yes, sir.
clarify the matter here. Let me show you what I've marked as Exhibit 17
Yes, sir.
For purposes of explanation, this is the letter that identifies by paragraph number the allegations. When you did your response, you responded by that. That's not the charge number, and that's the only reason I attached that is for purposes of explanation.
Let me look at that if you don't mind, Councilor. Thank you very much.
What is Exhibit 17 then?
Exhibit 17 is a part of Judge Allred's response to the charges.
Thank you.
I would object to this coming in as an exhibit because the additional allegations that were listed in there were dismissed in the informal stage, which are confidential pursuant to the Supreme Court rule. So, you know,
We can
deal with that later? Okay.
We can do that. I will agree to redact it. The only thing I'm concerned about is your response
Yes, sir.
to the allegation about the complaint and how it was resolved with Kentucky Utilities.
Yes, sir.
Which is referred to as allegation 16 on the document.
Yes, sir.
Okay. And I'll agree to redact that. Anything else that's below that or above?
I don't have a problem with you just admit allegation 16 with that on there, as long as you don't attach the sheet that has a bunch of other
That's fine. We can take
matters
that
that were
off.
dismissed in the preliminary phase.
And the only reason I did that, Judge, was for purposes of, at the time, the numbers were aligned, and I didn't want anybody to think that was charge 16. It wasn't. It was just for a reference point.
Yeah, because they were different allegations over time and different numbers, and I understand that. Yes, sir.
But in your response, which you sent to the commission with regard to the charge having to do with the contribution made by Kentucky Utilities, tell me if I'm reading this correctly, that you, number one, I did file a personal complaint against KU as a private citizen because I felt that they were improperly billing under a fuel adjustment clause. I feel that I had a valid claim. As an agreement between the parties to resolve the matter, I agreed to dismiss my personal claim in exchange for KU making a $12,500 donation to the playground project at James A. Kaywood Elementary. Did I read that correctly?
Yes, that was my response. Yes, sir.
And when you entered into this agreement with Kentucky Utilities, it was done through a conversation with their counsel. Is that correct?
To the best of my knowledge, Mr. Mando, this is one I really don't remember a whole lot about because it wasn't a long period of time, but obviously there was some type of agreement. Yes, sir.
Right. And what I'm asking, Judge, is whether or not you recall having a conversation with the attorney for Kentucky Utilities where this agreement was reached.
I remember a conversation with the attorney for Kentucky Utilities telling him that it was my desire to go ahead and dismiss this action because it became clear after I had gotten into this that KU was going to have about 200 or 300 attorneys on staff to battle me in regard to this. This action was initially filed as a result of the Franklin Circuit Court issuing an order striking down the fuel adjustment charge clause that KU had been using and other utilities had been using in their electric bills, which ever since I was a younger man in private law office, really did not like a fuel adjustment clause. I thought it was unfair to citizens that a utility could simply raise the rate of a electric bill solely on their whim, particularly when I was in a coal-producing county and knew that all power plants and utilities had long-term contracts with coal companies to where the price of coal never really fluctuated in those contracts. But it was always amazing to me that on your electric bill it would fluctuate on a monthly basis regarding fuel adjustment charges. So I, as a private citizen, when I saw on television that the Franklin Circuit Court had issued a ruling striking that down, immediately filed my complaint, and or soon thereafter, and hoped to try to get some vindication for that. It became obvious to me that it wasn't going to pan out because I didn't have the time or the resources to deal with it. And I did talk to, I'm trying to think, what was the gentleman's name?
J. Kendrick Riggs?
You know, I can't really remember if it was
At Stoll, Keenan, and Ogden?
I can't remember. All the big firms just kind of run together to me. I used to work in Lexington, and I used to know him well then when I was a runner, but I can't remember. But anyway, he was a nice gentleman, and he was a reasonable person. There are actually three lawyers, I think, in this thing, if I'm not mistaken. And I had indicated that I was going to dismiss my claim, and I did mention to him that there was a playground project for the children in this area. KU had a lot of bad PR because of the electric bills being $500 and $600 that winter before that. There was a public outcry for that issue, and I did say that I would dismiss it if they would consider making a donation to that. There was no signed agreement to that effect or anything of that nature.
And I